Hello, my name is Stefano Burchi. I am the chairman of the International Association for Water Law based in Rome, Italy, and I will give a presentation on the evolving legal framework for groundwater and aquifers, a domestic and international. This presentation will cover groundwater and aquifers in international law from the standpoint of the human right to water and international law that regards rivers, lakes, and aquifers that are common to two or more sovereign states, i.e. transboundary or shared. And secondly, I will present the salient features and trends in the domestic laws on groundwater and aquifers from a comparative law perspective. And will draw some conclusions. Now, regarding international law regarding freshwater resources, I should clarify at the outset that there exists no global legal instrument, such as a convention or a covenant, for the governance of freshwater resources on the planet. However, freshwater is targeted by international law from the dual profile of the human right to water and the rivers, lakes, groundwater and aquifers that form or are bisected by the international boundary line of states, and that is essentially what constitutes international water law, a particular branch of international law. Now, regarding the human right to water, at the end of a long process of forward-looking distillation of legal thinking and of state practice, a human right to water for the satisfaction of basic human needs has emerged and has been crystallized in two main instruments: Commentary number 15 to the International Covenant on the Economic, Social and Cultural Rights of 1966, that was issued in 2002 by the relevant United Nations body, and the UN General Assembly Resolution 64/292 of 2010, carrying the human right to water and sanitation. Now, I should clarify that neither instrument is legally binding. However, the human right that both articulate is reckoned to imply an obligation of states to not discriminate and progressively realize a right to water of sufficient quantity and of an acceptable quality that is physically accessible and economically affordable. This is primarily water for domestic use, i.e. drinking, washing, cooking, bathing, but also in the latest evolution of the human right to water is also water for subsistence livelihoods. This same right, human right, is nowadays written in the constitution of a number of states, as well as in the domestic water laws of several countries, both of which constitutions and domestic water laws confer on the right a binding force. And in fact, the same right has also been the target of significant pronouncements by the courts of law, both domestic and regional, as a result of litigation that has vindicated the human right to water, posited in the laws or in the constitutions. Now, international water law targets instead the relations between and among sovereign states as regards rivers, lakes, and aquifers that form or are bisected by the international boundary lines of states, and also known as transboundary or shared rivers, lakes, and aquifers and freshwater resources. This with a view to reconciling the interests at stake of the concerned states and minimizing the opportunities for interstate conflict and encouraging interstate cooperation. International water law consists of norms of interstate behavior of a general nature, derived from the practice of states, also known as customary international water law, and specific to given transboundary rivers, lakes, or aquifers that are cast in treaties and agreements that are specific to a river, lake, a basin, or an aquifer. And this is also known as conventional international water law. Now, where does one find customary international water law? The norms of customary international water law are codified in 2 global conventions and in the codifications proposed by some highly respected authoritative international institutions, notably the United Nations and the International Law Association, which is a non-governmental organization. The 2 global conventions are the UN Convention on the Law of the Non-Navigational Uses of International Watercourses, also known as the New York Convention, adopted by the UN General Assembly by a vote in May 1997, by a majority vote, in force since 2014, with 37 states as party to it, very few, in fact. And the second is the Convention on the Protection and Utilization of International Watercourses and Lakes, developed at the initiative of the United Nations Economic Commission for Europe and adopted by its member states in 1992, in force since 1996, also known as Helsinki Convention. Now, of note is the fact that, why did I refer to it as a global convention? Because even though it originated from within a regional grouping, mostly Europe-centered, since 2013, the convention has been open to accession by all states of the world beyond the ambit of the Economic Commission for Europe. And at this particular time, the convention has 44 states party, 3 of which are outside the ECE region, and all of them in Africa, Chad, Ghana, and Senegal. The most important codifications that reflect and crystallize the principles of customary international water law are that carried out by the United Nations in regard notably to transboundary groundwater and aquifers, that culminated in the draft articles on the Law of Transboundary Aquifers that is annexed to Resolution 63124 of December 2008, and the codification carried out by the International Law Association, which is a non-governmental body, and that culminated in the Helsinki Rules of 1966, addressing primarily surface waters, later complemented by specific rules on groundwater known as SOL rules, issued in 1980. Now, I should emphasize that neither codification has a legally binding force per se. However, to the extent that both codify principles of customary international water law, and as customary international water law is legally binding, the legal core of these codifications is legally binding. And what is this legal core? What are the rules of customary international water law applicable to both surface and groundwater? They are the principle, the rule that each state has a right to the equitable and reasonable utilization of a shared freshwater body, that each state must not cause significant harm to its neighboring states, that each state has a duty to exchange with its neighboring states information and data regarding the shared freshwater body, and that each state must provide prior notification of planned measures to neighboring states, and to engage in good faith negotiations with a view to reaching an agreement if the notified state raise objections. Mind you, the obligation is to engage in negotiations. The obligation is not to reach agreements. Now, with specific regard to transboundary groundwater and aquifers, they partake of the principles and rules of customary international water law in general that are cast in the global instruments and in the codifications that I've just mentioned, either by virtue of a physical link of groundwater to a surface water system, as in the Helsinki Rules of the ILA and in the UN Watercourses Convention, or regardless of such link in their own right, as groundwater, as aquifers, as in the 1992 Helsinki Convention and in the UN draft articles on the Law of Transboundary Aquifers. So, in essence, whereas the latter actually cover all kinds and manner of groundwater and aquifers, both rechargeable and non-rechargeable, the former cover only rechargeable aquifers. The UN draft articles on the Law of Transboundary Aquifers articulate the most comprehensive and forward-looking set of rules in the matter of transboundary aquifers. The UN resolution that carries the draft articles, and I must emphasize again, does not have a legally binding force. However, the few principles of customary international water law that are cast in there do have a legally binding effect. The draft articles cover aquifer utilisations, including in particular extraction of groundwater, heat and minerals, the storage and disposal of substances, harmful activities above or in proximity of an aquifer, the aquifer and the groundwater recharge and discharge zones, which is quite remarkable because the discharge zones in particular can be at quite a distance, a physical distance from the, such as oases and wetlands, at a physical distance from the aquifer as such. In addition to the basic rules of customary international water law that I mentioned earlier, the draft articles also articulate a number of forward-looking state obligations regarding in particular the protection and preservation of ecosystems that are dependent on groundwater, that is, wetlands and oases, the prevention and minimization of harm to the groundwater recharge and discharge zones, the prevention, control and reduction of groundwater pollution in implementation of the precautionary principle, which is quite relevant considering the vulnerability of groundwater to lasting, often irreversible pollution and damage. Regular monitoring, abstaining from uses of a rechargeable aquifer that may harm the health of the aquifer and its good functioning, and the maximization of the long-term benefits that can be derived from a non-rechargeable aquifer, also known as fossil, to be achieved through the planned management of the aquifer jointly by the states concerned or individually by each concerned state and harmonized. It is interesting to note, and I emphasize, draw your attention to the fact that in the draft articles there are specific provisions that address the specifics of rechargeable and non-rechargeable aquifers, which are quite different, one from the other. Now, very few agreements are on record regarding specific aquifers, and they are an agreement concluded in 2008 between the Canton of Geneva and French local government border entities regarding the management of the Geneva aquifer and the apportionment of groundwater and of the management costs of an artificial recharge plant located in Swiss territory. Two agreements made in 2000 by Chad, Egypt, Libya and Sudan regarding monitoring, data collection and exchange in regard to the Nubian Sandstone Aquifer System, a framework-type agreement concluded in 2010 by Argentina, Brazil, Paraguay and Uruguay in regard to the Guarani Aquifer, an agreement concluded in 2015 between Jordan and Saudi Arabia on the Al-Sak-Disi Aquifer, carrying a moratorium of extractions, the exclusive destination of extracted groundwater to domestic uses, monitoring and pollution control. A consultative mechanism has been in place since 2008 for the North-Western Sahara Aquifer System shared by Algeria, Libya and Tunisia, and a draft agreement dating back to 2014 carries a consultative mechanism and detailed rules for the joint management of the Ulemed and Taudenita-Nesruft Aquifer System located in the Sahelian region of Africa with seven countries sharing it. Now, groundwater comes also within the reach of some transboundary surface water treaties and agreements. For example, the 2002 Sava River Basin Agreement that provides for the integrated management of surface and underground water resources in the basin. The 1999 Convention for the Protection of the Rhine River Against Pollution that reaches out to groundwater that is connected to the river. The 1994 Danube River Convention that contains a number of provisions that address specifically groundwater in the basin. Two conventions for the sustainable management of respectively lakes Tanganyika and Victoria, both dating back to 2003, and that cover the system of surface water and groundwater flowing into the relevant lake from the territory of the states party. The revised protocol on shared watercourses in the Southern Africa Development Community region of the year 2000, that covers also groundwaters that, by virtue of the physical link to a surface water system, constitute a unitary whole and flow into a common terminus, the sea, a lake, or an aquifer. Last, I would like also to mention that the member states of the Orange-Senku River Basin Commission, that groups Botswana, Namibia, South Africa, and Lesotho in Southern Africa, in November 2017 decided to host cooperation in regard to the Stampede Aquifer located in that region, and that is shared only by 3 of the 4 states, and to nest it in a committee, a groundwater committee that operates under the Commission's technical task team in the framework, in the structure, within the structure of the Commission. That is, this is another way of bringing groundwater within the fold of a pre-existing surface water agreement and institution. Now, if we come to the evolving domestic legal framework for groundwater, the first item that springs to mind is the public property status of groundwater, because water laws have steadily and consistently attracted groundwater in the sphere of the state's public domain, public trust, or superior control powers. And as a result, groundwater is no longer the private property of landowners. There are several examples of these, contemporary and less contemporary so. However, exceptions persist, notably in the state of Texas, in the US, in India, and in Pakistan. Secondly, well drilling and groundwater extraction and use have been steadily attracted in the scope of regulation, notably through administrative permits and licenses that are time-bound and subject to terms and conditions, based also in particular on aquifer say yield determinations. In combination with extraction charges in implementation of the user-pays principle. With respect to groundwater pollution control, point source pollution is regulated through administrative permits for the discharge of wastewater on the ground or directly underground, often coupled with payment of charges in implementation of the polluter-pays principle. However, the direct discharge of hazardous substances and of pollutants to aquifers is generally prohibited. Non-point-source pollution, instead, is addressed differently through the regulation of land and of subsurface space uses, notably cultivation practices, landfills, waste dumps, and the underground storage of substances, and mining. Now, I draw your attention to the fact that these regulations are found mostly in non-water laws, and therefore coordination with water laws, and vice versa, is of the essence to ensure that different sets of laws work at a common purpose. Now, the human right to water that you remember I mentioned as one of the lead points in the international law as it applies to freshwater. Now, the access to water, both surface and underground, for the satisfaction of basic human needs is cast as a matter of human rights in increasing numbers of water laws that posit the human right to water as a matter of policy and principle, and, but not always, seek to also operationalize that right by a variety of means, notably prioritizing domestic water allocations, a number of examples I've given, directing government to guarantee access to unpolluted water for basic needs, directing government to set aside quality water for the satisfaction of basic human needs within certain quantitative limits and subject to respect for third parties' rights and for equality, non-discrimination, and gender standards. Now, contemporary water laws seek also to capture and mitigate the impact of land uses and uses of the subsurface space, on groundwater quality, and on the natural groundwater recharge and discharge processes, and on groundwater's environment support function in respect of notably wetlands and oases, and aquifers under stress in general. This issue of the land-groundwater interface has been emerging forcefully as one of the leading, forward-looking aspects of groundwater management and governance in contemporary domestic water laws. Now, the laws address and capture these water laws, capture this link between land and groundwater, the land-groundwater interface, by, as I said, a variety of means, by restricting land uses and practices that are the source of non-point pollution. You recall what I just said in this particular respect. By restricting select heavily groundwater consuming practices, notably paddy rice cultivation in states of the Indian Union, commercial forestry in the state of South Australia, and coal seam gas extraction in the Australian state of Queensland. They also do so by factoring the impact of on groundwater of land uses, including uses of the subsurface space, something that implies reaching out to and coordinating with land use, town and country planning legislation, and mining legislation. By also zoning the recharge and discharge areas of aquifers and aquifers under stress, thereby triggering restrictions on land uses that are inimical to the natural groundwater recharge and discharge processes and cause stress. Traditional groundwater uses and communities that are governed by customary law and practices play a significant role in rural groundwater governance in many countries. The interaction that is generated by the intersection of such uses and communities with modern water laws and with formal water rights holders has been addressed in the contemporary water laws through a variety of approaches. In particular, water laws have created a separate legal space for traditional users and communities and insulated the relevant rights and practices from the reach of formal water law and of formal water rights holders, or grandfathered traditional users and their customary rights and practices through the voluntary conversion of such rights to formal water rights, sought to minimize opportunities for conflict and to reconcile the traditional, customary and the formal water rights by taking into account traditional uses and rights in the licensing of water abstraction and of wastewater discharges, restraining the government's authority to grant formal water rights if the customary rights of traditional communities are affected, and according traditional water users priority of allocation. The involvement of users in the governance of groundwater is promoted and regulated in the water laws in a number of ways. Through the formation of formal groundwater users groups for the management of aquifers under stress, for example in Mexico and Spain, and through the representation of groundwater users in the basin or aquifer authorities, agencies and councils, for instance in France, Mexico and Spain. In addition, groundwater users can commit contractually with government to adopt relief measures in overexploited aquifers. For example, in France, this is a French approach that has been successfully replicated in Morocco. In conclusion, international law has accredited the human right to water for the satisfaction of basic human needs, for domestic but also for subsistence livelihood purposes. However, the operationalization of such right lags behind and is very much left in the hands of litigation and the courts of law. International law regarding freshwater bodies and resources in general, and aquifers and groundwater in particular, that are common to two or more states, has evolved to the point where generic but legally binding rules of customary international water law have emerged to orientate and, if need be, restrain states' behavior with the objective of promoting cooperation among the states concerned. Detailed legally binding rules have been agreed by the states that are a party to the two only global conventions on record regarding transboundary waters and/or a bilateral or regional treaty or agreement on record regarding individual surface freshwater bodies or groups of them, some of which reach out to groundwater that is connected to the surface water system, and the handful of bilateral or regional agreements on record regarding individual aquifers. Domestic laws on groundwater, on the other hand, have evolved to the point where groundwater has been attracted steadily in the sphere of the public domain and is no longer regarded as private property in a vast majority of countries. Groundwater extraction and use and pollution from point sources are regulated. So is pollution from non-point sources. However, the target of regulation are the uses of the land and of the subsurface space. The human right of water features in an increasing number of statutes, not only as a matter of principle and/or policy. The land-water interface is captured at different points of intersection, also through coordination with relevant non-water laws. Traditional uses on the ground are accounted for and protected from the appetites of formal water rights holders. And groundwater users are called upon to play a role in the governance of the resource, and increasingly so. Thank you for your attention and interest, and here is my email address in case you wish to contact me.